Insurance professionals work hard every day to keep people safe. But as technology transforms the industry, how can insurers protect not only their clients, but also shield themselves from ever-changing cyber risks? My name's Elizabeth Blossfield, and I'm the host of the Insuring Cyber Podcast, a monthly look into how the world of cyber and the business of insurance are connected. Hi, everybody, and welcome back to the Insuring Cyber Podcast. For this episode, I spoke with Andy Sambandam, founder, CEO, and Chief Technology Officer of privacy management software company Clarip. We talked about AI adoption and data governance in the insurance industry, and Andy shared insights on how insurers can strengthen data quality, manage third-party risks, and build privacy frameworks that enable rather than hinder innovation. We also explored common pitfalls companies face when scaling AI and what leading organizations are doing right. Check it out. Hi, Andy. It's great to be speaking with you today. How are you doing?
I'm good. Thanks for having me.
Yeah, thanks for taking the time. I'm really looking forward to this conversation. I know that AI is a big topic in the industry right now, so there's a lot to talk about.
Yeah, absolutely. You turn left, you turn right, all you hear is AI.
Exactly. It's true. And it touches so many different areas of insurance. And I know that insurers have been moving a little more quickly to adopt it now, but you've mentioned in past interviews that data governance is sort of lagging behind. So I was curious, what are the gaps that you're seeing there and why do you think it's still lagging?
Yeah, I think, when you think about any innovation, right, it's especially with AI, it's, moving at lightning pace. And, a lot of insurers are moving to adopt AI because they don't want to be left out. So you always have this fear of missing out or FOMO. And but when it comes to governance or, even the privacy laws, that's something that most people overlook. One of the reasons, is because even if you think about ownership, right? So when you look at the data ownership is not entirely, laid out clearly. And sometimes when you say the data is AI ready, it's not actually AI ready because it's all, living in silos within your business. If you're, insurance carrier, regardless of the industry you're in, it could be in auto insurance, home insurance, health. You have data that are sitting in different silos within your business, but they're also not always categorized and labeled correctly, right? That also it's inconsistent between different systems. And sometimes some of the data is very old. Some of them are decades old. No one has actually done a proper data mapping exercise or data governance exercise to understand what data they have. So governance, actually has to start and stop at the data itself, not necessarily on the model. So you need to make sure that you have some clear rules that you can use the data to train the models. And you also want to make sure that, who are the third parties you're sharing data with, what is structured, what is unstructured. And you also, especially in the insurance industry, you want to also make sure that, there is no bias. There are certain fairness checks that are there. But right now, some of those are pretty inconsistent or reactive at best.
Yeah, that makes a lot of sense. And as you mentioned, the AI systems can only be as good as the data that they're trained on. So you want to make sure that the data is really sound. And you sort of answered my next question as well, because I was going to ask you some of the steps that insurers can take to properly train their AI models. Do you have anything else to add about that?
Yeah, absolutely. So, sometimes, you want to think about use case, right? So what is the use case you're looking to solve for? So not just necessarily feed all the data to AI, but start with the use case driven data. And you also have to put some real ownership around data and the models itself. So let's say, if you have different roles within your organization, you got to identify certain people as data owners. And you want to make sure that the data owners are accountable for quality and freshness and lineage. And also you can make the AI model owner accountable for performance, bias, and outcomes and things like that. So it's really creating that segregation. So you put ownership and have data stewards within your organization and have them, focus on the data itself, the quality of data itself, the lineage and all those things, but then have the AI model owner to be a different role or a separate person, and they're accountable and responsible for the outcomes and bias and performance and things like that. So that kind of clear-cut breakdown could help. And also you want to make sure that you clean the data. Sometimes the data you have is already corrupt to a certain degree. There are duplicates, there are inconsistencies. The definitions are not the same across multiple lines of business. So if you're looking at underwriting, they could be having a certain definitions for certain purposes, but then that's not the same case throughout the whole 9 yards. And you could be having claims processing using a different definition. So you really want to make sure that the labeling definition is all accurate. And then also, you want to test for bias. because once when the bias is already in the model, then it's really hard to eradicate it, right? So you want to test quite a lot before you actually make the model go live. And oftentimes, another thing I see is consent is lacking. So you want to make sure that you have consent captured and obtained from the end users before you can actually use that to train the model.
Yeah, that's all really great advice for steps to take to train the models because, as you mentioned, bias has been a big challenge with AI in the past. You want to make sure that you're ridding it of bias and making sure that you're training it properly. And this kind of leads into my next question as well, because you've also spoken about how third-party data sharing is becoming one of the biggest hidden regulatory and reputational risks for insurers right now. So I'm curious what you're seeing there and what should insurers be aware of when they're working with third parties?
Yeah, I mean, this is a great question, right? So third parties, when you think about third parties, most insurers, they're thinking, okay, we got, I don't know, 10, 15 or, 25 different vendors we work with, and these are the third parties we work with, and that's it, right? What they forget now is sometimes there are, I'm not even exaggerating here, sometimes there are hundreds of third parties that are in your ecosystem. Now, even take any insurance website, for example, or a mobile app. All of these things are actually having lots of different third-party vendors within your ecosystem. They are having their cookies, beacons, pixels, JavaScripts, and different tags that are embedded within your website or mobile app. In some cases, they actually have, SDKs that are embedded on your apps, whether it's a web app or a mobile app. You have all these different third parties. So when a customer is utilizing your platform, their information, starting with their IP address, starting with your personal information or PII, personally identifiable information, all of this information is actually moving to multiple third parties without consent. And this is something oftentimes insurers don't think about. They think their website is the e-commerce team is responsible for the website. But then a lot of the time, oftentimes, it's sensitive information, right? So this information actually, now there are privacy laws. I think there is more than 25 states with their own privacy laws now. Each of these privacy laws give people certain rights, right? So imagine you are a resident of California or Virginia. You can actually go to a company, the insurance company, and then say, hey, my name is John. What data you have on me? Or delete my data, or do not share my data with anybody else. So when you make these requests, the insurer has an obligation to fulfill that. And there are certain exemptions, whether it's under GLBA or financial services regulations. You can say, hey, we cannot delete your stuff because we need to keep it for 7 years or whatnot. But in some cases, you're obligated to give back that information or process an opt-out request. And if you don't know all the vendors you have in your ecosystem, that becomes a big problem. And then you have the unhappy customer complaining it, or they go to the AG's office, and then before you know, you actually have a reputational risk because now it's become a news article online. So that's going to eventually impact actually additional things as well, where new customers that may be considering you, they may not want to go with you because now you have a reputational issue to deal with. And, it's really the overall thing is the privacy and security posture you want to demonstrate, matters. Right. So because your customers are looking for that. So you really want to always keep an eye on what are the third party vendors we have on the ecosystem and what data is it shared with those people? Is it shared through just JavaScripts and cookies, or is it shared through API calls that are happening quietly behind the scenes that you're not aware of? So, one of the advice that I would give would be, do an audit, right? So at least once a month, you need to do an audit. Run a scan on your systems to identify what are the different third-party vendors are there, what data are they collecting, so that you can really, either prevent that type of sharing if it's not authorized, or ensure that you actually have consent from your customers.
Yeah, doing those regular audits is so important. And that's also an important point you mentioned about the reputational damage, especially in the digital age where everyone's on social media and reviewing different companies and information can spread so quickly. Protecting that reputation is an important point as well. And I know that there have been some barriers to innovation for the insurance industry. And one that I've heard a lot of talk about is that insurers worry that stronger privacy controls will slow down innovation. So based on your work with different carriers, how can companies modernize privacy operations without sort of slowing down AI and digital transformation?
Yeah, sure. That's a great question. I think I would say it's actually a fear, right? So you think, hey, privacy controls are slowing down innovation. Not necessarily. If you modernize your privacy operations, if you know what's going on within your ecosystem, even starting with the scans, that doesn't slow down innovation. In fact, that could be another area that you can innovate within your organization. Another point I would make is consent. We talked about this just a few minutes ago. Having consent is super important. So if you have consent, then you're able to innovate. Because people, are not saying they're not going to share their data with you, right? They are willing to share, but you need to be transparent. That's where it becomes super important. You don't want to hide behind a lengthy privacy notice or a legalese and not have anybody understand what's going on. But if you really break it down, what data are you collecting? Who are you sharing it with? And what's the reason you are sharing that with? If you simplify this to this what, who, and how, then you have more people willing to give consent. And once when you have consent, you can actually use that information or de-identified information to a model and continue with your innovation strategies because now you have consent. The key here is, number one, being transparent, and number two, doing innovation within your privacy operations, and number three, actually having consent. And also number four, which is the sort of the often overlooked area, utilizing the data for the purpose in which you collected the data for, right? So we call it purpose limitation in the privacy world and the security world. So you want to make sure that whatever information you collected, whatever PII you collected, you use it only for the purpose for which you originally got that data from the end user. But having consent and having, breaking it down on what purposes are you going to use for, then you can actually use it because somebody gave consent.
Yeah, that makes sense. And I can imagine that doing all of these initial steps up front might feel a little bit intricate and detailed, but probably putting in all of that work at the beginning actually speeds up the process in the long run. So that makes a lot of sense.
Yeah, exactly.
Yeah. And then I'm also curious, just in your work, what are some of the more common mistakes that you see companies making when they're trying to scale AI? Or on the other hand, what do you see companies doing well that should be continued?
I mean, the common mistakes would be, again, like I said, lack of consent, right? So you assume you have consent, but you don't. Or another common mistake is, you think when you share data with an AI model or within your systems from one system to another system, you think, hey, we anonymize the data, so it's anonymized and everything is good. Or we're not sharing PII. But oftentimes, what you don't realize is even a simple thing such as IP address is considered PII. If you have a customer or end user visiting your mobile app or website and how they are moving the mouse, their keystroke patterns and things like that, they are classified as biometric data. So most people don't know that. Now you could be violating the state of Illinois BIPA Act, which is specifically talks about biometrics, and you could be really breaking multiple privacy laws across different jurisdictions. So it's really you want to understand what data you're collecting, and then once when you collect the data, is it really PII, and can this be tied with something else? Those are the things you want to keep an eye on first. The second thing is, when you think you anonymize the data, is there a way for somebody else or some other system to reverse engineer that? Can it tie back to the individual again? So I've seen, time and again, you have companies thinking, okay, this is anonymized, this is de-identified, without really realizing that can be reverse engineered back and tied back to an individual. So when that happens, that's a problem for the carrier. One of the clients that we worked with not too long ago, we have this, technology that we developed. It's a patented technology, and we're able to scan, mobile apps and websites and simulate customer journeys, and also do what's called automated data mapping. So we can scan internal data sources, data that's both structured and unstructured, and identify what is sensitive data, what is PII. So when we were running a scan with one of these large insurance companies, what we found was we found Social Security numbers unencrypted sitting in a database. And what had happened was, some developer, an engineer, took a production database and duplicated that into their own development environment. And they were working on it, they were testing something, and then that's it, they forgot about it. So our scans actually found literally close to 1 million records sitting there unencrypted. So this is not only a privacy violation, this is a PCI DSS violation, which is a payment card industry standards. So the chief information security officer was able to quickly go in, bring this server down and delete the data or encrypt the data and take necessary measures. So things like this, this is not something you're thinking about every day. What your internal IT teams are doing, are the developers following the protocols that you set forth early on, not to take production databases or not to copy that, not to duplicate that? Do you have different silos where you have potential sensitive information, whether it's SSN numbers or credit card numbers, just sitting there without you knowing about it. The only way to find that is really to run some audits and scans internally to understand that. So those are some of the things I can think of.
Yeah, that's some great advice and some important real life examples to learn from as insurers are thinking about implementing AI even more and making sure they're doing it thoroughly. And this has been a fantastic conversation. I've learned so much from you, and I think our listeners will too. So thank you again so much for taking the time to speak with me today.
Thank you. Thank you so much for having me.
It was so great to speak with Andy, and we have another great guest for this episode to dive into the use of AI and data, but this time in the legal industry. I spoke with Sean Burke, Managing Director at specialty insurance solutions provider Gencap, about the evolving intersection of generative AI and professional liability risk in the legal industry. Sean broke down how attorneys are using AI and how E&O policies are responding to AI-related claims. He also spoke about emerging risks in the AI space and shared guidance for both insurers and law firms on how to navigate these challenges and prepare for what's ahead. Here's what he had to say. Hi, Sean. It's great to be speaking with you today. How are you doing?
Great, Elizabeth. Great to see you. How are things?
Yeah, I'm doing well too. Can't complain. I'm really looking forward to this conversation. I think it's a really fascinating topic, especially, AI has been such a big topic in the insurance industry. So I'm interested to hear things from your perspective. But before we get into some of the questions, could you just kind of talk a little bit about your background and some of the work that you do at Gencap?
Yes, certainly. I'm a managing director at Jencap, and I lead the West Coast team with respect to our professional liability practice group and transactional liability. And within that, we see a lot of different verticals of different insurance placements with respect to industry verticals. But in a particular focus on our practices, we do deal a lot with certified professionals, which includes financial institutions and lawyers, which does have a really interesting vignette of exposure to AI more so than general industry. So I think it's a very interesting discussion to have at this time.
Yeah, I think so too. And I'm glad to have you here speaking about this today, because I know you have a lot of expertise in this topic. And as you mentioned, we're talking about generative AI in the legal landscape and how that impacts professional liability. So just to start off, how are attorneys using generative AI tools today, and how widespread has that adoption become so far?
Yeah, generally speaking, I'd usually drop this into three buckets. The first being research, whether that's summarizing and researching case law. It can be utilized drafting issues outlines. And within that drafting, it can be used to draft emails, briefs, demand letters, discovery requests, contract clauses, and obviously editing as well, whether that's tone clarity and converting bullets to notes, prose, or reformatting. Operationally, it can be used in the workflow capacity also. That is, intake triage with respect to clients. It can be deposition outline starters or document review support. Or taking past work and putting it into internal playbooks and creating templates. In terms of how widespread it is, I think that's the interesting question, right? It is very broad, the adoption, but the maturity is uneven. Many firms have shadow AI, which is people using in the tools informally, and fewer have governance approved tools, policies, training, logging, and guardrails around AI. So AI adoption is already widespread. What's more rare is disciplined firm-wide governance.
Yeah, that makes a lot of sense. And I guess that kind of leads into my next question as well, because I was curious what some of the risks are for attorneys and law firms. And at what point does use of AI sort of shift from a productivity tool to, professional liability exposure?
Yeah, absolutely. The big risks, and maybe highlighting 4 or 5 of them, obviously, I think it's been well understood and publicized that accuracy and hallucinations, AI-generated citations that are used in court filings being wrong, out-utilizing of outdated law or jurisdictional mismatch in outputs that come from AI when people are utilizing it to research. The risk spikes when outputs go client-facing or court-facing. There's other issues around confidentiality and privilege. Uploading sensitive client information into a client tool can create confidentiality issues, privilege waiver arguments, and then obviously data retention and vendor exposure. So with that, the issues become, what is your supervision? Bar rules broadly require competence and supervision of work delegated to others. AI becomes delegation if it's generating substantive legal work. So that requires the attorney to have supervision. Other, matters. If you are a firm that's involved in consulting on screening or HR advice, you have to be aware of bias and discriminatory outcomes of outputs related to AI, especially in employment, housing, or consumer matters. And that can turn into malpractice and/or regulatory exposure if not closely guarded. So the question comes, when does it become a liability exposure? I would suggest when it creates or modifies legal positions, whether that's arguments, citations, or interpretations, touches client confidential data without guardrails, or is relied upon without verification. Or what we are seeing also is a potential for client-facing productizing way of using the AI, whether that's a portal, automated advice, mass outputs. It's a productivity tool until it becomes a decision maker. And the moment it influences advice, filings, and client outcomes, it becomes a professional liability exposure.
Yeah, and that's an important piece of advice. You don't want it to make your decisions for you. You want to be able to at least double check all of the work that AI is doing. And that's a great overview of some of the risks. There's so much to pay attention to with these AI tools. And I can imagine that's leading to some uncertainty as well. And I know that you've mentioned before that there's often confusion around E&O coverage. So I'm curious how current professional liability policies are responding to AI-related claims right now.
Yeah, it's interesting because the core framing of an AI legal malpractice suit, well, it'll be pled as traditional malpractice. The allegation is a failure to meet a legal standard of care. The claim will deem the lawyer, not the algorithm, of course. So the malpractice claim doesn't blame the model, it blames the lawyer. Now, the standard of care in the legal profession requires competence, supervision, and verification of delegated work. And delegation does not eliminate the duty on the attorney. So AI is a delegation tool. So and failure to review an AI output is a potential breach of your professional duty. A carrier's argument could be that if AI generated the substantive work product, there was no human in the loop, no human meaningfully reviewed it, then no professional service was actually rendered. And instead, it was an unsupervised technology deployment rather than it was a professional service. So is this a technology failure or is this a professional services failure? Now, I would suspect most courts would say this, that the client is retained by the lawyer, they're not retaining AI, the duty attaches to the lawyer's supervision, and failure to review is a professional negligence. I think where the argument really gains traction in a more realistic claim scenario is when the firms do productize AI. When it's automated legal outputs with minimal attorney involvement, subscription-based or tech-enabled legal services model, this is when it becomes, this is a legal service. Is it a technology service? And the LPL definition of professional services doesn't apply to this scenario. So AI doesn't remove the duty of care, it raises the bar on supervision. And from a coverage standpoint, the question becomes whether the lawyer exercised judgment or simply deployed software. So these are the things that insurers are grappling with today. And as they're receiving these claims, and it probably is going to lead to future generation of insurance language, which is going to be forthcoming very soon.
Yeah, it'll be interesting to see how this evolves because I know we've been having these conversations for a while, and we've even seen some high-profile cases involving AI-generated fake citations that lead to sanctions or fines. And I'm curious what these incidents tell us about some of these risks that firms are facing, and what should insurers be paying attention to regarding those risks as well.
Yeah, 100%. What it does tell us right now is that this isn't a future risk; it's a present tense operational risk. The most common root cause is there's no verification step and no documentation process. That basically you're taking the output and you're putting it into a brief that looks professional and submitting it. We have seen many cases where that has happened and there has been censures. There has been fines and penalties put on attorneys and even referral to bar associations, where insurers care obviously signals a potential for small to mid severity claims on a frequent basis. It also provides reputational harm and possible disciplinary actions. And what they need to pay attention to from an underwriting lens is, do you have a mandatory verification process? Are there approved tools, enterprise and secured versus public tools, which is very important if you're utilizing an AI system that is a closed system and you're not using open AI and putting client data, in the open sphere, in the public sphere. So those items, as well as whether or not you are training on hallucination risk, jurisdictional testing, source validation, those are all controls, workflow reviews, and audit trails that, insurers are starting to inquire about now of their customers, whereas a year ago, firms weren't being asked these questions. It's not that AI is dangerous. It's that AI plus a weak process is dangerous.
Yeah. And I think that's an important point because as you mentioned earlier in the conversation, you need those humans in the loop to be checking the AI and making sure that the processes aren't weak. And I know that you mentioned that we might see some evolving language around insurance covering AI issues, but sort of looking ahead, how do you expect professional liability coverage and AI risks to evolve? And what else should insurers be doing to prepare for the risks ahead?
Yeah, certainly. And I think, we can draw analogies to cyber, certainly, when we went to the work from home in the pandemic environment, where we went from very basic cyber questions to more detailed risk control questions in terms of how you're utilizing your network, right? And what type of protocols do you have? And it raised the requisite bar amongst firms to have access to coverage without restriction by having certain protocols in place, whether that was MFA, EDR, et cetera. And likewise, I think these are the questions they're going to be start asking of law firm leaders was, disclosure, what type of AI are you using? We use Gen AI for X and not for Y. What are your governance protocols? Do you have written policies, training, acceptable use protocols, and human review requirements? And the human review requirements, who are reviewing? Is that a senior attorney? Is it a committee? Where does the review process actually take place? Discussions around tooling, again, the topic of, is this a closed system where you have enterprise contracts with data retention policies, or are you utilizing open AI? Client engagement and consent is also very important. How are you disclosing the AI use to clients? Interestingly, a lot of clients are coming, especially larger corporate clients, are saying, we want you to utilize AI in certain capacity. We'd much rather have you utilize the efficiencies of AI than utilizing a paralegal and billing us out 500 hours to research an issue when this can be done in a matter of minutes. But how do you take that output and then review it? And then like cyber as, also a guideline, incident response is very important. If there is a bad AI output slips through, do you have an internal escalation path to address that concern? So these are the type of questions that legal leaders in the firms need to be grappling with. And these are the questions that will be asked of them as we go forward with carriers. Now, to the question of how coverage may evolve, obviously underwriting becomes more governance-based. I do believe we'll see more affirmative language. Instead of blanket AI exclusions, you may see defined coverage grants, defined conditions, or potential sublimits for specific AI loss scenarios, depending upon where your governance sits on the spectrum. That could be, if you're using open source AI, potential exclusion versus closed source, as an example. So the claims are shifting from getting the law wrong to a systems process failure. And as a result, insurers are now going to be underwriting to the systems and the process more so than to other aspects of your area of practice.
Yeah, that's really interesting, the insurance piece of it, and to see how it's sort of evolving as we get our hands around the use of AI. And as you mentioned, it's not all bad. There are, opportunities to increase productivity and cut costs with AI tools. But you mentioned it's important to be careful about how you're implementing those, and a lot of important questions for law firm leaders to be asking and insurers to be asking of them as well. So this has been a really helpful discussion and a super timely topic. So thank you so much for taking the time to speak with me today.
Absolutely. Enjoyed the conversation. Thank you for having me.
Well, that's all for this episode. Thanks to Andy and Sean for joining me, and thanks to all of you who tuned in. You can check out this and previous episodes of the Insuring Cyber Podcast at insurancejournal.tv or wherever you get your podcasts. And stay tuned for another episode next month. In the meantime, feel free to reach out to me at eblastfield@wellsmedia.com with any comments or questions. Talk to you next time.